I have prepared a paper. It covers 3 issues. However, given this is basically a half-hour talk, at least the last 2 I won't get through, but just briefly, the first one is that I'll mention briefly is Primary RE Limited and Great Southern Property Holdings, which Sam mentioned. Now, that's a critical case for the content and effect of notices under Section 146 of the Property Law Act. What I've put in the paper I think is self-explanatory. I've told you the relevant provisions of that case to read. It's an enormous case, so you don't need to read the whole lot. There's a defined number of paragraphs, but it's a very good decision by Justice Judd, which sets out, lays to rest a lot of misapprehensions about Section 146 notices and their effect. And the other issue that I probably won't get to deal with is whether a tenant can set off a damages claim against the obligations to pay rent, and that issue has arisen because of a recent case in the full federal court. The position in Victoria is that where there's a clause that says you've got to pay rent without deduction, basically the law is the tenant has to pay the rent irrespective of any cross-claim for damages. Anyway, you'll see towards the end of this paper that I briefly deal with that. There hasn't been a huge number of developments in retail leasing in the past year. However, one area that has been heavily litigated is Section 52 of the Retail Leases Act. And Section 52 implies into a lease a term that the landlord is responsible for maintaining in a condition consistent with the condition of the premises when the lease was entered into, the structures of and fixtures in the retail premises lease, plant and equipment, appliances, fittings and fixtures provided under the lease by the landlord relating to gas, electricity, water, drainage or other services. So it's actually a term implied into the lease. Now this changes the common law because at common law, in the absence of an express lease covenant, a landlord's under no obligation to repair leased premises. Now, you'll see in paragraphs 3 and 4 I've set out the whole of Section 52. You'll note the introductory words, the landlord is responsible for maintaining in a condition consistent with the condition of the premises. If you look at the sub-clauses, which are set out in paragraph 4, now I'm going quickly because of the time, so if you forgive me, you'll see in sub-clauses 3, 4 and 5 the word repairs arise. There's reference in sub-clause 3 to repairs, 4 to repairs, 5 to repairs. These are clauses that explain further Section 52. Now, an issue that immediately arises, and I'll be dealing with this later in more detail, is this clause anything more than requiring repairs? Does maintaining mean something wider than repairs? That is not entirely clear. I'll be submitting that basically it's a keep in repair covenant and no more than that. But I want you to note at the bottom of Section 52, there's a note there. This is in paragraph 4 on page 2. Note, Section 39 regulates the ability of the landlord to recover outgoings, including the cost of repairs. Section 41 provides that capital costs are not recoverable from a tenant. Now, I mention that because it's relevant to the issue of whether the landlord can recover from the tenant the costs of complying with Section 52. That particular note has been dealt with in some case law. Now, what does reliance on Section 52 entail? This is what Deputy President McNamara had to say about Section 52 in a case called My Club. Reliance on Section 52 of the Retail Leases Act 2003 necessarily entails a comparison of the condition of fixtures, services and so forth at the time the complaint is made against their condition when the relevant lease was entered into. So that immediately raises the question, when is the lease entered into? If a tenant occupies premises for 5 years and there's an option for another 5-year term, what is the date, and assuming the tenant exercises the option, what's the date at which the condition of the premises is assessed? Is it at the commencement of the first 5-year term or at the commencement of the second 5-year term? In Ross Hunt, the tribunal considered Section 7 of the Act, which sets out when a lease is entered into, and held that in the circumstances that I've just referred to, the example I've just given, the relevant date was the date the new term commenced following the exercise of the option. So it wasn't when the tenant first entered into the lease, it was when the second term commenced. So you can see that has a massive implication for both landlords and tenants. From the tenant's point of view, it's not very good because they would want to go back as early as possible in the piece. and the landlord would want it to be as late as possible in the piece. So from the landlord's point of view, it was a good decision. So it appears that each time a lease is renewed, Section 52 will be triggered for the purposes of defining the landlord's obligations. And it appears that it's not possible to provide some sort of defining moment for ascertaining when the condition of the premises, when they were first occupied by the tenant. It's often argued in VCAT that Section 52 should be given a benevolent construction in favour of tenants. Now, that proposition has been rejected by Deputy President McNamara. He said, "In my view, this is not the appropriate approach to construing a provision such as Section 52. The Retail Leases Act and cognate legislation regulates the rights and liabilities between one another of landlords and tenants. It is a zero-sum game. A right given to a tenant is an obligation imposed on the landlord. An immunity given to a landlord is a right removed from the tenant. The policy of a statute such as the Retail Leases Act is to draw what Parliament regards as a proper balance between the rights and liabilities of landlords and tenants in the particular area regulated by the Act. There is no broad outer area from which beneficial principles can be drawn. The only way in which it can be determined exactly how the balance between the rights and liabilities of landlords and tenants has been struck by Parliament is to analyse in accordance with normal statutory maxims, the words which Parliament has used. Hence, it is only if it can be demonstrated on the balance of probabilities that there has been a deterioration of the state of the air conditioning, in this case, appliances since 1 August, that the applicant Ross Hunt will be entitled to any relief. So the tenant has to establish on the balance of probabilities that the landlord has breached Section 52. Now, Section 52 originally provided that landlord was responsible for maintaining in good repair. Now, you'd appreciate straight away that's a much higher obligation imposed on landlords than just maintaining in a condition that they were in at the start of the lease. Now, this was amended in 2005 to limit the landlord's responsibility to maintaining the premises. Now, that came about because the state of Victoria was leasing quite a few premises around the state, ski chalets and things that were often in a poor state of repair, and the tenants were paying nominal rent. And when they woke up to the Section 52, as it then was, that a landlord was responsible for maintaining in good repair, the state of Victoria was lumped with huge bills. So immediately the Act was amended. The meaning of maintain has not really been explored in any depth. As I said, all the subsidiary provisions refer to repair rather than maintain. But it is an issue because most leases, for example, require tenants to paint during the term of the lease. Now, that could be regarded as maintaining. So there's going to be an issue somewhere along the line about whether something is a repair, whether the provision only concerns repairs, or whether it goes beyond repairs to normal maintenance work, like painting. Now, VCAT has held that keep in repair could mean, in extreme circumstances, that the only course open to a landlord is to replace some aspect of the premises, but only to the degree that is necessary to give the tenant the same conditions as at the commencement of the tenancy. Now, I'll come back to this later. What it effectively means that is a landlord might have to replace something, an old part with a new part, and it's bad luck. If the only way of replacing that thing is to put something new in, the landlord is stuck with that. There's no way out of it. For example, another example might be if statutory standards have changed, building regulations have changed. The landlord would have to replace that part of the building in accordance with the building regulations, not what was there originally, which can't be built anymore. As to the meaning of repair, I've set some of that out in Section 13. It's a fairly broad term. In general terms, repair may include restoration by renewal or replacement of subsidiary parts, but does not extend to reconstruction of the whole or substantially the whole of the building. And then there's a quote from Lord Justice Nichols, which I won't bother you with now, but over the page I think that's particularly useful. The quote by Lord Justice Sachs: "It seems to me that the correct approach is to look at the particular building, look at the state at which it was in at the date of the lease, look at the precise terms of the lease, and then come to a conclusion whether on a fair interpretation of those terms in relation to the state, the requisite works can be fairly termed repair." Now, there's always going to be arguments about what's repair and what it goes beyond repair. But there is a lot of case law on it, but again, it always comes back to what is the landlord being asked to do. Now, while it's very easy in general terms to describe the operation of a keep in repair covenant, its application is not always clear. For example, what happens if a landlord leases a service station property? He has four underground petrol tanks. After the lease commences, one tank is abandoned and replaced by the landlord with a new tank. The new tank becomes contaminated with water. Can the landlord contend that Section 52 doesn't apply to the new tank because it was installed after the lease commenced? You might recall we're talking about the condition as at the commencement of the lease. The answer to the question is no, because the relevant comparison is not between the condition of a particular fixture or appliance or plant or equipment, but the condition of the premises as a whole. Now, when the tenant leased the premises, there were 4 operating underground tanks. So that's what the tenant's entitled to. There's another piece of confusion that sometimes arises, that is, people often think that a breach of Section 52 also entails a breach of the covenant of quiet enjoyment. Now, they're quite separate things. Cause of action under Section 52 doesn't give the tenant a cause of action for a breach of covenant of quiet enjoyment. Section 52 is concerned with problems in the area under the tenant's control. A breach of the covenant of quiet enjoyment normally relates to problems caused to the tenant's premises by things happening on premises which are under the landlord's control. Now, in Ross Hunt, it was argued that the landlord's refusal to repair and upgrade air conditioning constituted a breach of the covenant of quiet enjoyment, alternatively a breach of Section 52. The claim based on the breach of covenant of quiet enjoyment failed because the air conditioning system formed part of the leased premises. It had nothing to do with an area that was under the landlord's control. However, the Section 52 claim was successful. Now, I mentioned in paragraph 17 there that a tenant can effect urgent repairs in specified circumstances and seek reimbursement from the landlord for the cost of those repairs. Can the landlord get round these provisions? Justice Croft in Retail Leases Victoria has suggested that a provision in a lease that imposed a put-in repair obligation on the tenant, in other words, an obligation that was higher than the landlord's obligation, an obligation to place the premises, plant and equipment at a higher standard of repair than they were in when the lease was entered into, would not be void under Section 94 of the Act. In other words, Section 94 of the Act says you can't have a provision in a lease which is contrary to or inconsistent with a provision of the Act. And so what Justice Croft is saying is that if you, for example, said the tenant has to replace the air conditioning every 3 years, that would not be a breach of Section 52. It's requiring the tenant to do something which is at a much higher level than the maintain requirement imposed on a landlord. Obviously, for that to be effective, you'd need to ensure that the lease contained a capital works obligation on a tenant pursuant to Section 41(2) of the Act, which I'll just briefly deal with. It's a bizarre provision because Section 41(1) says provision in a lease is void to the extent that it requires the tenant to pay an amount in respect to the capital costs of a whole lot of things. Then you go to subsection 2, but subsection 1 does not operate to render void a provision in a retail lease requiring the tenant to undertake capital works at the tenant's own cost. So you can get the tenant to do something at its own cost, but you can't get it to contribute to capital costs. Also, you would need, to make that kind of thing effective, you would need a provision in the lease that enabled the landlord to recover outgoings under Section 39 of the Act. We'll come to that. Now, I've only seen this issue dealt with once in Computer and Parts. The tribunal characterised a clause in a lease that required a tenant to pay $3,300 for air conditioning as being a put-in repair obligation and held that the tenant had to reimburse the landlord for that cost. The analysis is pretty thin in that case, and I suspect that part of the case, if it's determined by someone else, would not be followed, but I certainly think it can be done. Now, what remedies are available for a breach? Ordinarily, the court will not grant specific performance of a covenant to repair. While this rule is not rigid, the usual remedy is damages. However, VCAT has a great armoury of provisions available to it, and in computer parts, before the case even commenced, the tribunal said to the parties, look, if I'm going to order the landlord if I'm going to hold the landlord was in breach of section 52, I will order the landlord to undertake the repairs rather than requiring the parties to have another hearing about the quantum of any damages. In that case, the tenant got up at the beginning and said, look, we're not in a position to argue damages, and there'll have to be another hearing about that. And the tribunal said, look, we don't want another hearing. We'll just order the landlord to do the repairs if, in fact, the landlord's found liable. So you'll find a decision on that point even before the case was heard and determined. Section 91(1) of the Act, the Retail Leases Act, enables the tribunal to order a landlord to perform its obligations, to require a party to do or not do anything, including provide specified facilities, services, fixtures or fittings. Now, these provisions are mentioned in my paper, so don't think you've got to go away and work out what I'm talking about. Given that Section 52 implies obligations into the lease, the question arises whether a landlord's failure to comply can be held to be repudiatory conduct, usual contract law principles. Now, this issue was raised in a case called Delaveris, but was ultimately not decided. But in Delaveris, the tribunal had to consider the relationship between the usual no deduction rent covenant and the statutory repair covenant. I said at the beginning of this, most leases say the tenant's got to pay the rent without deduction. Now, the tenant withheld rent because of a failure to carry out urgent repairs. Now, Delaveris concerned the Retail Tenancies Reform Act, but the provisions were basically identical, sections 25 and 47. And this is what the Deputy President had to say in refusing a claim for possession by the landlord. This is the first step in the reason. In accordance with well-established practice to allow set-off of a liquidated sum incurred by a tenant in meeting a repair obligation imposed... I'll start again. It is in accordance with well-established practice to allow a set-off of the liquidated sum incurred by a tenant in meeting a repair obligation owed by the landlord and reducing the rental liability accordingly. So, tenant got to first base. The second step was this. What the tenant then argued was that because of the equivalent of Section 94 of the Act, the old section, that is the section that says you can't have a provision that's contrary to or inconsistent with a provision in the lease, the tenant said, look, this without deduction provision concerning rent is contrary to or inconsistent with the lease. In circumstances where the Act implies this provision into the lease, the landlord can't then say, but the tenant's not entitled to any monetary relief because the rent has to be paid. And this is what the Deputy President had to say. It seems to me arguable first that the withholding or at least the delay of the payment of rent was justified. I'm just going to skip down a couple of lines. We'll recall that the covenant to pay rent under this lease was a covenant to pay without deduction. The authorities are not at one as to whether the inclusion of these words is sufficient to prevent any equitable set-off being relied upon to impeach the demand for rent. For the reasons which I gave in Whitell, the balance of authority in Victoria favours the view that the words without deduction exclude a tenant from relying upon equitable set-off to impeach the demand for rent. Here, however, the covenant which the tenant alleged was being breached was one which, in accordance with, I'll use the modern provision, Section 52 of the Act, the lease was taken to provide that it was a statutory implied covenant. Section 52, statutory implied covenant. Section 94 of the Act provides that a provision in a lease is void to the extent that it claims to exclude the application of any provision of the Act. In my view, the inclusion of the words without deduction in the covenant to pay rent is avoided by Section 94 to the extent that it limits the effect that the statutory implied covenant to repair would otherwise have. Hence, a breach of the repair covenant would be available as a set-off in the present case. So, that's quite a significant decision. So if the landlord is in serious breach of Section 52, that can be used by a tenant to argue that there's been a repudiation. The next issue is, can the landlord recover costs of complying with Section 52 from the tenant? In paragraph 22, I set out Section 39 of the Act, which says that a tenant under a retail premises lease is not liable to pay an amount to the landlord in respect of outgoings, except in accordance with provisions of the lease that specify the outgoings that are to be regarded as recoverable, and I won't read it any further. Section 41 of the Act, you might recall I've taken you to that, firstly makes void a provision in a lease to the extent that it requires a tenant to pay an amount in respect of capital costs. But then 41(2) doesn't render void a provision in a lease that requires the tenant to undertake capital costs at its own cost. Now, can the landlord use those provisions to recover the cost of complying with Section 52? Well, you would think so. And you might remember the note I mentioned at the foot of Section 52, which seems to make it clear that that was the intent. This was on page 2 of the paper, right at the bottom. Note, Section 39 regulates the ability of the landlord to recover outgoings, including the cost of repairs. Section 41 provides that capital costs are not recoverable from a tenant. Well, you think that note being there, the intention of Parliament was that the landlord could recover those costs. However, in what's generally regarded as the leading case in this area, VCAT has rejected the view that landlord can recover the costs from the tenant of complying with its obligations under Section 52. That case is Cafe Dansk. This is what Deputy President McNamara had to say. I find Dr Croft's sceptical views on this point compelling. It would, in my view, make a mockery of Section 52 if Parliament, having allocated the responsibility for repairs to the landlord could then send the bill to the tenant for the cost of carrying out those repairs. To attempt to reach this unlikely result by reliance on the note at the end of the section is, to quote Lord Salmon, like trying to suspend a 3-tonne truck from a cobweb. Even if I were wrong on this point, the strategy for a landlord to recover the cost of compliance with his Section 52 obligation from the tenant would depend on there being a covenant in the lease, making these amounts recoverable as outgoings. There is no such clause in this lease. The covenants requiring the tenant to carry out the repairs itself do not deal with any outgoings issues. So, strictly speaking, his comments are obiter because the lease didn't have the necessary mechanisms to recover those costs in any event. But given the authority that Deputy President McNamara has, I would suggest that most other members will follow what he said there. However, the arguments supporting the landlord's rights to recover from the tenant are not as flimsy as the Deputy President suggested. The explanatory memorandum refers to the note, which I've taken you to, and says this: the effect of the note is to highlight other provisions in the Act which, together with the application of Section 52, clarify that while the landlord is responsible to arrange and carry out repairs under subsection 2, the costs of those repairs, other than capital costs and the costs of urgent repairs, may be passed on to the tenant if they've been specified in the lease. Now, in the Cafe Dance case, it doesn't appear that the explanatory memorandum was provided to the Deputy President. I'm just briefly going to deal with some of the cases that have occurred in the last year. Well, the first case was earlier than that. My club. After commencement of the lease, the premises were reconfigured from office space to a gymnasium. When the lease was entered into, the air conditioning system was old. However, it did introduce fresh air into the premises. A gymnasium has much higher air conditioning standards than office space, so when the tenant started operating a gymnasium, the air conditioning system really was quite hopeless. The landlord did install new air conditioning units, but they didn't introduce fresh air into the premises. The tribunal accepted that the landlord wasn't required to upgrade the air conditioning standards. In other words, the standards for an office space were the appropriate standards. However, because the original air conditioning units introduced fresh air into the premises, the landlord's obligations under Section 52 meant that the air conditioning units had to give direct fresh air access to the outside. So the landlord was liable. The next one is computer and parts case. The leased premises suffered from air conditioning problems and roof leaks. Air conditioners seem to figure in all of these. A special provision had been included in the lease that required the landlord to ensure that all electrical, air conditioning, heating and cooling equipment were in working order. Now this is actually critical in this case and has occurred in a number of the cases. There was a provision requiring the landlord to do things. The landlord didn't do those things. And the landlord in the trial argued that, look, I didn't do those things, that is true, but the condition for the purpose of Section 52 is the condition that the premises were in, not the condition they should have been in if I had performed my obligations. VCAT would have none of it and said, no, you were supposed to do those things at the start of the lease. That is the condition which we're going to assess the premises by. The tribunal said a number of things. The landlord wasn't required to maintain premises in a state of disrepair that was identical to the state of disrepair when the lease was entered into. but the state of repair need not be any better than at the commencement of the lease, but the same benefit to the lessee as was agreed to be provided had to be provided. Section 52 was a keep-in repair obligation as opposed to a put-in repair obligation. I've mentioned that to you already. If parts failed, they had to be replaced with replacement parts that in the absence of adequate second-hand parts might need to be new. While Section 52 didn't mandate compliance with any legislative standard, a landlord could not contravene a building or related law or regulation. And if there was an aspect of the building that was legal as at the date of its construction but was no longer legal, repair of that aspect of the building would not be a betterment for the tenant. So the landlord had to do it. Bad luck. If compliance with the lease entails some measure of upgrade, because those involved in carrying out works must comply with the Australian standards, so be it. In this case, it's quite an interesting point arose. The roof was in very bad condition, and you'll see there's quite a debate in the case about whether, an internal debate, internal to the member really, the member's writing down, I wasn't sure whether to order replacement or to just order repairs, and the member said, look, I think that even if I just order repairs, there'll have to be further repairs done. Maybe I should order a roof replacement. In the end, the member just ordered roof repairs, acknowledging that the parties might be back there having further arguments later on. The last case I'll deal with is a case called Savers. This case concerned the tenant was leasing two premises from landlords, and they were operated as a single shop. Again, the premises weren't properly maintained. It was alleged that roof, drainage and floors were in poor repair. Breaches of the leases in Section 52 are alleged. The tenant sought orders that the landlord undertake repairs. The leases and earlier leases contained terms that obliged the landlord to undertake repairs. Again, the tribunal was able to say that's the standard. What the landlord should have done, that is the standard. The landlord can't take advantage of its own wrong. There was an interesting argument run that the landlord actually argued that the higher standards imposed under the lease were in breach of Section 52 because they were contrary to or inconsistent with Section 52 and therefore void. You might recall I've mentioned that provision, Section 94. The tribunal wouldn't have a bar of that and said, look, if parties wish to contract for something more than is provided for under Section 52, that was fine and that wasn't contrary to or inconsistent with the Act. I suspect that issue will arise again, but obviously the high moral ground there is with the tenant. There was also a discussion about whether landlords could artificially define the premises so as to reduce their obligations. You'll see that referred to in subparagraph B. I think that's really all I need to do with out of all of that. The lessons from all this, from these cases are, firstly I'd suggest avoid litigation if possible. The cases that have been effectively run as building cases, have become vast cases, massive costs incurred, experts on both sides, goes on for days and days, dealing with minor items. Your head will spin when you read some of these cases, what the member had to go through. You know, did that little piece work? Was that piece old? You know, it just went on and on and on. So if you can, settle the cases. That's my first piece of advice. Secondly, both tenants and landlords should make sure they have a reasonable idea about the state of the premises when the tenant first goes in and on each recurring renewal. Make sure that you do that, particularly tenants, because of the effect of Section 52 only operating when there's a renewal, not from the original date, operating from the renewal, the tenant's got to be on top of the state of the premises the whole time. I have seen sometimes the state of the premises being defined in leases. Now, you've got to be careful about that. Landlords traditionally like doing that by saying that the standard was excellent. I've seen that a few times. But of course, given the Section 52 obligation, that could really come back to bite landlords. That's all I really want to mention about Section 52. There's one argument that hasn't been run, which I suggest will be run shortly, sometime soon anyway, that is this. I've just taken you to cases where the landlord had an obligation, a contractual obligation to do things, and the tribunal said that's the standard. Well, it seems to me you could equally argue that, just assuming there's a lease that's gone for 5 years, we're in a second-year term. tribunal could equally find that under the first lease, the landlord was required to maintain premises to a certain standard, failed to do so, and that should have been the standard at the commencement of the second lease. So why couldn't you then argue that in fact the standard that the landlord has to meet is the standard as at the date the first lease commenced? I'm sure that argument will be run sometime soon. Have I got any time left or not? No. Okay, but I certainly, on the Section 146 point of the Property Law Act, critical case to read, primary RE, beautiful explanation about how it works and what should go into notices and what it all means. And a lot of myths are dispelled. Thank you. Oh, yeah.
Now, Sam heard what I had to say about you questioning him after the end of Robert's paper, and so he's made an early escape. No, in fact, he had other pressing engagements, so he gave his apologies, and I pass those on to you. Nevertheless, Robert is quite happy to answer questions on relief against forfeiture or on anything arising out of his paper. Thank you.
I have a question which could lead to a relief from forfeiture application. Landlord leases premises to 3 tenants. Notice of exercise of option is given. Lease is prepared and submitted. Lease is returned by the tenants with the names of one of the tenants deleted with an explanation saying the tenant left this business 6 or 9 months ago. The question, first of all, is that an assignment of lease? And it's and the landlord's consent to assignment hasn't been requested. If it is a transfer of lease, then could the option have been validly exercised? And then going on from that, from the tenant's point of view, could there be any successful application for relief from forfeiture by the 2 remaining tenants?
Well, we'll start at the rear end of that. The only people that could seek relief against forfeiture are the tenants, and I would think there would have to be the 3 original tenants. But if you go back to the beginning, when the option was exercised, either it was exercised by, you haven't told me when the first tenant, sorry, one of the 3 tenants left, whether it was before or after the option was exercised.
Prior to the option being purportedly exercised.
Well, you've got a nice messy situation.
I'm sure you're available.
Yes. Well, that would require a bit of thought, all of that, I'm afraid. One thing I was going to say about relief against forfeiture, there's one thing that a lot of people don't realise is if you've been thrown out, you can actually go back in on a temporary basis until you get your application ready. There's authority about that. So you can go to the tribunal and say, look, we're not ready to make our application for relief against forfeiture yet, but we want to get back in, and you obviously have to give a whole lot of undertakings and what have you, and you can be let back. It's particularly important for shopkeepers and restaurants, let back in on a temporary basis until you're ready to make your application. So you have what's called an equity to seek relief against forfeiture, and the tribunal will recognise that.
Surely in those circumstances you've got to make good for these breaches.
Well, you've just got to give certain undertakings and say, look, we'll comply with the lease until the application is ready, and obviously you have to have an application on fairly shortly. But for initially, you don't need a huge amount of proof to get back in. Okay.
What about rent?
Well, you obviously have to pay rent.
Okay, so you something like rent, you'd have to
I'm
bring
not
it up to
saying
date.
I'm not saying you can get back in without say, for example, arrears of rent. You would have to bring the arrears up, but often there's other breaches involved as well.
Robert, you've referred to Section 41, and that provides that capital costs are not recoverable. If there is an argument between landlord and tenant as to whether a cost is capital or not, what's the test for a capital cost? Is it based on tax and accounting principles?
Well, that is a messy question, and a whole lot of issues can become involved there. Tax and accounting can be relevant. I have not personally been involved in a dispute about that, but it's not an easy it's not easy to provide an off-the-cuff answer for any particular item. I mean, there's almost a little bit of a definition in 41.1 anyway when it talks about the capital costs of the building in which the premises are. It talks about plant and equipment. So it's, I mean, it must be cases sometime or other, but it's not actually an easy answer to give off the cuff.
Well, ladies and gentlemen, thank you very much for your attendance this morning at Green's breakfast briefing. That brings our proceedings this morning to a conclusion. So I send you forth to fight the good battle in the trenches.